Right at the heart of the Scottish justice system, there's this incredible institution. It's almost 500 years old, and it has the power to shape laws and even hold the government to account. Today, we're going to break down exactly what it is, the Court of Session.
So let's start with a question. When you think about Scotland's biggest, most serious legal battles, we're talking disputes over millions of pounds, or even challenges to government power, where do those fights actually happen? Where are they won and lost?
Well, the answer is right here, the Court of Session. And get this, for nearly half a millennium, it's been Scotland's supreme civil court. It really sits at the very top of the legal pyramid.
So, to really get a grip on its power today, we've got to go back. We need to look at its foundations. Because trust me, this court was absolutely built to last. Just think about the history here for a second. It was established way back in 1532. That means the Court of Session has survived some of the biggest moments in Scottish history. The Act of Union, modern devolution. And through all of that, its power wasn't just left alone. It was intentionally protected. Okay, but it's not just about, disputes between people or companies. The Court of Session acts as a kind of constitutional watchdog. It has this incredible power called judicial review, which means it can hold public bodies, yes, even the Scottish government itself, to account. It basically checks if their decisions are legal. So how does a court this powerful actually work day to day? Well, it's not just one big courtroom. It's actually split into two very distinct parts, and each one has a really critical job to do. Think of it like this. The court is divided into two houses. First up is the outer house. That's basically the trial court. It's where a case starts, and a single judge makes the first call. Now, if someone doesn't agree with that decision, they can appeal to the inner house, and that's where a whole panel of senior judges takes a second look. And this is a huge deal. When the inner house makes a decision, it's not just for that one case. That ruling becomes what's called binding precedent. It basically sets the rule book that every other civil court in Scotland has to follow. It literally shapes the law for the future. But, even a 500-year-old institution has to change with the times. And a pretty major recent reform completely shook up the rules for one of the most common types of cases it used to hear, personal injury claims. Okay, so before 2014, things were pretty flexible. If you had a personal injury claim, a lot of the time you could choose to take it straight to the Court of Session no matter how much money was involved. Then 2014 happens, and everything changed. And it all revolved around one specific number, £100,000. That figure became the new magic number, the new dividing line in Scottish personal injury law. Basically, a new law came in, the Courts Reform Act, and it set this new rule. If your personal injury claim is for 100 grand or less, it has to go to the sheriff court now. And that one simple rule had a massive effect. It rerouted tons of cases, leaving the Court of Session to focus only on the most serious, highest value claims. Okay, so if there's this new £100,000 cutoff, how does a personal injury case even get to the Court of Session anymore? Well, it turns out there are a few different ways in. Right, there are pretty much four main gateways. The first one is the most obvious. The claim is worth more than 100 grand. Simple. But a case can also get in if it's super complex, or if it's one of those judicial reviews we talked about, like challenging a big decision by a public body. And the last way is on appeal. If a lower court case raises a really big legal question that needs a final answer from the top. So, you might be thinking, okay, it hears fewer cases now. Is it still as important? And the answer is a huge yes. In fact, you could argue its influence is even more focused and more significant than ever before. Here's the bottom line. That reform really concentrated the court's power. Now it only deals with the most catastrophic, the most complex injury cases, where you need that top-tier judicial expertise. And crucially, through its inner house, it's still the one setting those big, binding precedents that define the legal rights for every single injured person across Scotland. I think this quote really nails it. Even though its caseload is more focused, the Court of Session's main job hasn't changed a bit. It is there to be the final word, the ultimate decider. This is the place where law isn't just followed, it's actually made. And that really leaves us with one final thought, looking to the future. This institution has managed to adapt for 500 years. So as our world keeps changing and our ideas of justice evolve, you have to wonder, how will Scotland's oldest court continue to redefine what fairness means for the next generation?